morning. Please be seated. This is the time and date set for oral argument in cause number CV170604, Lane versus Galvin Peak Estates, LLC. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. I've heard that somebody wants to do something a bit different, so you have 20 minutes to reserve your time as you see fit. Appellant's counsel is responsible for watching the clock to reserve a portion of their time, if desired. Also, we've read the briefs, we have conferenced this case, and are familiar with your arguments. At this point, counsel, you may proceed.
Thank you, Your Honor. May it please the court, my name is David Abney. I'm here today with my co-counsel and friend, Joel Robbins. It's an honor to appear in front of you, as always. It's also an honor to appear at this high school. Both of my sons graduated from here, so I hope the audience will cheer appropriately. Steve Lane stepped on some kind of explosive device on November 4, 2013 at the Star Flash Ranch. He had no inkling that there was any danger of any explosive substances or devices when he came onto the ranch. He was there simply to help a couple of people move off, Perrin and Garner. The trial judge said and held that they were properly and lawfully on the land and that they were properly and lawful sublessees. There's been a cross appeal, but the other side hasn't challenged that particular holding. He was there to help them move off, and as part of his compensation for doing that, he was told that he could take scrap metal, whatever he found there, and sell it if he could.
Was that the sublessee's right to give him that authority to do that?
Yes.
How's that?
Well, because it's a summary judgment, we have to take all reasonable inferences for them and view the facts in the light most favorable to them.
Well, what evidence is there that would indicate that they had that authority?
The manager of the limited liability company, GAVILAN Peak, that owned the property, knew that they were taking the scrap metal off and approved them doing it. In fact, said that was a great thing for them to do.
You said he approved it. Are you referring only to the mere statement, thanks for keeping the land clean, or whatever it was?
No, there were several statements of that nature where he said that's okay. The inference from that is it is indeed okay to take the scrap metal. It's a good thing that you're doing. Another reasonable inference from that is that you're helping actually us as the owner of the land by improving the property, by getting the scrap metal off of it.
He also took a refrigerator, didn't he?
He did. A refrigerator that Garner described as junk, old, rusty refrigerator. If that doesn't qualify as scrap metal, I don't know what would. And of course, you have to take the reasonable inference and view the evidence in the light most favorable.
Didn't the sublessee say that she did not authorize him to take the refrigerator?
No, she did not. She said it was junk, and he was allowed to take scrap metal off the property. There was a complaint to a police officer who investigated whether there had been some sort of theft going on, and he said basically that as far as what was in Lane's vehicle, it was stuff that may or may not have been of any real value. So if you view this pessimistically, you can say, well, it had real value, but we're not allowed to do that in this kind of case because it ended before a trial. And every reasonable inference in the light and all the evidence has to be viewed in the light most favorable. So taking all that together, he was there with permission from the sublessee, legitimate sublessee, to do two things. Both of those things help the landlord, by the way.
Hold on, because you said a legitimate sublessee.
Right.
The original lease did not authorize a sublessee.
Technically, it did not.
Well, not technically, it did not.
It did not.
Okay.
Actually and technically, it did not, absolutely. But the trial judge said they're legitimate lessees, they're properly and lawfully on the property. And they were allowed to stay there for a period of time after GAVILAN Peak knew that there were sublessees there. There were some efforts to work out an arrangement that they would pay to be there. That didn't work. And so GAVILAN Peak said, well, you have to leave. And as part of the effort to leave, they asked Steve Lane to come on and help them pack up and move their property off. And as part of what he was doing there, he was also taking up scrap metal. So he got two benefits going to the landlord. You know, I'm stressing that not to say that Steve is just this wonderful guy. He simply is a person. That's fine. What I'm saying is that he has moved now out of the licensee category and into an invitee category. Because
How does he move into the invitee category? You're saying because the landlord knew that he was doing something that was helping him, that turned him into an invitee? Is that what you're suggesting?
in broad strokes, if I may narrow that, yes is the answer, but I need to qualify my yes a little bit and explain it, if I may. He was there doing something that was of a mutual benefit nature. He was doing something to help the landlord, getting the people off the property and cleaning up the scrap metal. And the landlord, and he was also doing something for himself. So
even if the landlord
benefit.
doesn't know and hasn't asked that someone do whatever, take the property, take the refrigerator from the property, we would say he's an invitee as opposed to a licensee?
Yes, I think so, because there is the mutual benefit. If there wasn't a mutual benefit, you'd have a lot stronger argument that he was a licensee, but because of the mutual benefit, he falls in the category of an invitee.
Well, let's stop with mutual benefit. There had to be some benefit to Mr. Lane to get the scrap metal. That's
Sure.
what he was there for. So he was there for financial compensation for the gathering of the scrap metal. That, in fact, was his business, correct? That's what he engaged in.
That was a large part. I mean, he was helping friends, the Chelsea and Garner, but he's also certainly hoping to get something out of the scrap metal.
All right, so the landlord wasn't receiving any compensation for the removal of the scrap metal, is that correct?
No, what the landlord was getting was the scrap metal gone.
All right, and you seem to infer that the sublessees were authorized to remove the scrap metal. Is there anything in the record that would illustrate that they were also authorized to have others engage in that activity?
I think I missed the last part of the question.
When they said they were cleaning up the property, the sublessees, did they have a discussion with Mr. Johnson where he said, great, clean up the property and have as many people come on to clean up the property as you will?
No, Your Honor, they did not.
And when I looked at the record, I think there is a statement by the sublessee female who said that I told them specifically not to take any of the appliances off the property. Do you recall that in the record?
I do, but I think a reasonable inference for that is an appliance that had any sort of value and that wasn't junk or scrap metal. But she was very specific in describing the rusty old refrigerator as junk, and that would put it in the category of scrap metal. That's a reasonable inference. Now, a jury could say, oh, hooey on this. We think a reasonable inference is you can't take any appliance, even if it's totally decrepit, rusted, and worthless junk. But then again, a jury could say anything that's decrepit, rusty, old junk is simply scrap metal, and you're allowed to take that. And then once again, we've got a definite benefit going on with the landlord. And I stress that because there's the three categories of people who come onto your land: invitee, licensee, trespasser. We want to get in the invitee category naturally enough because the protections that the landlord is supposed to give to the invitee are stronger. But even if Lane was just considered a licensee, a landlord still has a duty to warn of hidden dangers that the licensee coming on the land won't know about. And he had no clue whatsoever. And in fact, the sublessees didn't have a clue.
Is it a duty to warn of dangers that the lessor reasonably knows about?
Yes, however, that's an incomplete statement. It's not only to warn of dangers you reasonably know about, it's also to warn of dangers you reasonably should know about.
And what's your best evidence that the lessor should have known about the condition on the property?
Well, the managing partner, you start with Johnson, the managing partner of this limited liability company. Charles Byers, who had owned the land, who had made munitions there, explosives, grenades, tested them by the thousands and thousands, and he had told specifically Johnson, there are still booby traps on that property. There's booby traps that were set against me. You know, Byers was a bit of a paranoid kook.
He told him they were still there after the state's remediation effort?
Yes, there were still booby traps on the property. At several points he told
because
Johnson. In fact,
Charles testified in a deposition that he communicated to Johnson there's absolutely no way that any munitions of ours was left over on the property.
Yes, he said that at one point. He also said at other points that on numerous times he had told Johnson that there were booby traps still on the property. He'd
Well,
also,
but those, I thought those were references to before the state came in and remunerated the property.
there's no qualification there. He said there were still booby traps there when he was talking with Johnson about it, and that was after the remediation effort. Of course, the effort to clean up the property was incomplete. The feds, the FBI, the Alcohol, Tobacco, and Firearm, and the EPA came up with this magnificent plan to build a huge berm, this earthworks around the explosives area, and set fires and blow it all up. Of course, the neighbors in the area were not happy about the thoughts of rocks and things falling on their heads from this, what would have been a massive explosion, and they stopped that. So the feds were not able to complete their efforts to clean up the property. And the state admittedly did not clean up the property thoroughly, although they declared they did. But it's like Nixon at Vietnam saying we've won, or Bush in Iraq saying we have victory. It was just crazy because they didn't complete the job at all.
But you're saying when Johnson is buying the property, he was told there are still booby traps on this property.
Yes, Your Honor. And not only that, he was also told in detail
See,
by...
I have to tell you, I've read this record, and I don't see this in the record.
And Mr. Abney, I'm going to ask you to direct us where it says still. When I read it the way Judge McMurdy read it, which was there were booby traps on the property, not there are still booby traps on the property. So if you could get that, and I'm not going to ask you to do it right now, but if you can get that to us, I would appreciate it.
Because he did specifically testify, absolutely no way that any munition of ours was left over on the property. I don't know how clear that could be.
He absolutely did. Of course, Byers is a convicted felon, and you can certainly take that into account and think, a jury would take that into account in thinking about his reliability. In fact, when Johnson was testifying at deposition with Byers in the room, he was too scared to give any opinion about his credibility. He's testified, I won't do it, because he's in the room. But at the opening brief on pages 29 and 28, there's references to the record where on numerous occasions Charles Byers had told Johnson that there might have been booby traps on the property, that there were booby traps on the property.
But there might have been, but why wouldn't that be something that's taken care of through the state's remediation, through either the federal government or the state's remediation efforts? Why would you assume, if you're Johnson, that the state would leave booby traps?
Well, Johnson's buying a property that Byers had already told him had been the site of testing and building and exploding thousands and thousands of
But you would pay
munitions.
several $1 million or whatever the purchase price for something knowing that it's booby trapped, that hasn't been completely remediated? Wouldn't that be the expectation, that the property's remediated? That's why we're willing to buy it.
Well, I don't know what they were thinking when they bought this, other than there was a history of this explosive stuff, a history of the remediation, and followed by no investigation by the buyers, no due diligence to find out. Send an expert on the property, take samples, find out what the heck is actually going on the property.
But so you're
None of
saying
that
you
happened.
have a duty to follow up if the state issues a statement saying we've remediated this property, assuming Johnson's not aware of the disclaimer. But if you just look at the state's statement that we have remediated this property, is there a duty to go and search every inch of the property or bring someone in to comb the property at that point?
Well, if the state tells me anything, I check, because I don't trust the state. And I think a buyer really ought not to
You want us
trust.
to come out with an opinion that the state cannot be trusted?
Well, it's sort of common sense. I don't know if you want to put that in opinion, but if the state says everything is fine, the first thing I do is grab my wallet. I worry when you see things like that. And if he had done some due diligence, even in the paperwork where the state transferred the property back, it specifically said the remediation is not complete.
Okay, well, let's say without that paperwork, what would you have someone do if the state just makes the statement, we've remediated this property?
Well,
You're saying they need to bring in an expert to go and search the property at that point?
Number one, I would consider the source. If a convicted felon tells me everything's fine,
But no, we're talking about the state has issued a statement saying we've remediated the property.
I would want to double check. I want to see every scrap of paperwork on that property. And if I had the slightest qualm by reading, for instance, the statement made by the state that it's not fully remediated, I'd want an expert out there to check it over. Because
That's a compounded situation, though. We have the seller's property disclosure, can you hear me? The seller's property disclosure where they said there was no hazardous material, okay? So buyer says that in a document that most buyers rely on when purchasing property. Then we have the state who makes a public statement that says, citizens of New River, it is safe to go back into your homes, we've got it under control. And then more removed, we have Robert, the brother of the convicted felon, who is the only one that apparently on this record received the disclosure that reserved liability to the state for any unexploded ordnance. So you have this whole chain of events. What is your best evidence that Galvin Peak, Johnson in specific, knew there was anything remaining on that property?
Okay. The standard is not just knew, but should have known. And he was told, buyer specifically told him there's still booby traps. And number two,
So let's stop there. You admit there is nothing in this record that says he has actual knowledge. So you're hanging your argument on should have known.
no, he had actual knowledge. When buyer says there's booby traps on the property, that's actual knowledge that there's a problem with the property.
But that assumes that it was after the state had kind of declared.
I think that's a reasonable inference, which I have to keep going back to that, even though I sound like a broken record. But when you cut off a case before it gets to the jury, the jury can say, I don't believe this, I don't believe that, I'm not going to take that inference for you, I'm going to view the light most unfavorable to you, anything they want. Trial judges don't get to do that. He's supposed to look at the evidence, trial judge is supposed to look at the evidence in the light most favorable
But
to the
that's
non-moving
the evidence that you're focusing on. If the statement were clear that before the state's remediation efforts, there were booby traps on the property, is there something, if he said it that clearly, what other evidence would you be relying on? Or that you're just relying on his statement that there are or were or are booby traps on the property?
No, I'm relying on that for actual knowledge, for the constructive knowledge, or for the duty to go out and do some more investigation. The terrible history of the property, which you should at least go to the state and say, I want every scrap of paper you have on this. And the state would have to disgorge everything under the public records laws, and you would have found immediately the state is hedging its bet, saying it's not completely remediated. We admit that. And the state came in after the feds had failed to remediate it. So if you just look at the paperwork like they should have done, you would have found out, yeah, there's problems with the property.
Isn't it the seller's duty to disclose that information?
Oh, sure. But you can't rely on sellers either. I'm sorry, but the buyer
Okay,
has
so
to
we're
believe.
not
Trust
going to
no
rely on
one.
the state, we're not going to rely on the seller.
Trust no one.
Is there anybody we can rely on, Mr. Edmond?
Well, I rely on my wife. No, you have to be, when you're dealing with millions of dollars in an investment in land, and there's any hint there's a problem with it, you have to be cynical.
And I don't disagree that it would be the best practice, but what I'm asking you is, did Johnson have some sort of independent duty to investigate because he didn't trust the seller? I mean, he knew all of these things happened, but when the feds and the state came to remediate and they disclosed publicly that the land is perfectly safe to all the residents, what clued them in that they needed to go and investigate further when the seller says everything is fine? My
Well-
property disclosure, my SPUD says nothing dangerous here.
Charles Byers admittedly was the spokesman for the seller. He's a convicted felon. He told
Do we have
him-
any evidence that Johnson knew that
Oh, yeah. Byers, it's in the record, and I don't have-
before he engaged in the purchase? He
Oh,
knew he was a felon.
Yeah, he went over the history of the property. He said, I was convicted for this, that, and the other. Yeah, there's no question. Byers told Johnson about that stuff, and he told him about the history of the property, remediation efforts, making 10,000 grenades there a year. I mean, you've got to wonder, when anybody tells you that and you're buying property, well, did some of those grenades accidentally get left somewhere? You've got to worry about what's happening here. And in fact, we tend to forget, the state says everything's fine. Well, of course, everything wasn't fine. And Lane nearly blew his leg off, and then when there were investigations into the property after that, the investigating authorities found 97 blasting caps, they found grenades, they found explosive materials. I mean, the state lied. No question about it. Now, whether Johnson should have been cynical about that, he should have been. He should have investigated it, at least to the sense of going to the state and say, give me your papers, I want to double check on this. Absolutely, he should have done that. I think I have a couple minutes I'd like to reserve, if I may.
Thank you, Mr. Abney.
May it please the court, my name is Justin Ackerman, and with me at council table is John DeCara on behalf of GAVILAN Peak. I think Your Honor had referred a minute ago to, I would like to request just 1 or 2 minutes as a reply because I have cross-appealed. I leave it up to the court to do that in my own time.
And I will let you be the master of your own time.
Thank you. Where to start? Your Honor, it is very clear, I think, from this record, as the court has already identified, that, Garner and Perrin, first of all, knew this property was dangerous under their statement provision. That wasn't very heavily touched on in Mr. Abney's presentation of the case, but I would like to touch on that very quickly. The evidence in the record, and it's uncontested, they found grenade pull pins, used blasting caps, grenade fuses, spent shell casings, and a powder explosive within the property before this incident.
Does that go to booby traps? That might highlight that they were manufacturing explosives, but how would that lead them to believe that there are booby traps on the property?
Well, it is based on Mr. Perrin's military experience, and there's testimony record that he told Ms. Garner that these are indicia of bomb ingredients used to make bombs and booby traps, and that is her basis for believing that the property had those things and why she believed it was dangerous before the incident giving rise to the action. And it's undisputed. In addition to that, the testimony is undisputed that, within a week before this incident, they had concerns about being on the property and were vacating the property.
Well, they were vacating the property because they were told to leave.
They were, and I do concede that. But they did have concerns about being there. And whether or not they didn't heed those concerns, I don't think matters for purposes of Restatement 358. If they were aware of it and had a concern to be there, their duty is triggered to warn their guests of any dangerous condition on the property, and they did not do so. It's undisputed that they did not warn plaintiff when he was on the property the things that they found, concerns that they had. And that in and of itself triggers Restatement 358. GAVILAN Peak is absolved of any duty to warn or inspect the property, and that's very clear under the Cola case. The court in that case, it was a sliding glass door, and the tenant of the premises had lived there, had known that this sliding glass door was not made of safety glass, it was made of plate glass. And when a 6-year-old guest was in the house and presumably ran into the door or somehow crashed into the door and was injured, the family sues the landowner, and the court had said very clearly, because the tenants of the property had appreciated the condition and realized it was made of plate glass and not safety glass, their duty to warn was triggered, and they did not do so, and therefore the landlord was absolved of any requirement to inspect or warn of the property.
Isn't there a higher duty when you're talking about explosions versus
I
a
don't
piece
think
of
it-
glass in a shower?
I'm sorry. I don't think the duty changes because of the nature of the dangerous condition on the property. I mean, the restatement doesn't articulate any sort of higher standard based on what potential danger exists in the record. And to the extent of the
Well, hold on for a second, because our Supreme Court has said that a landowner has the ordinary duty of care to inspect the premises when he has reason to suspect defects existing at the time of the taking. Doesn't that mean that he has that duty to inspect? Especially if we're talking about explosions.
I think that's outside the context of Restatement 358. I think there is an ordinary duty on a landowner beyond 358.
Well, the restatement doesn't trump the Arizona Supreme Court.
It certainly does not, Your Honor.
Okay.
But at least this court has adopted Restatement 358 in the Picola case. And to the extent that the knowledge is required of the tenant, I have to go back to Picola again, just to give you a for instance of what the tenant knew, the testimony of what the tenant knew to trigger the restatement provision. It is, my dad is in construction. I knew back then you used plate glass. I'm going to assume I probably knew that it was plate glass. I didn't think it was safety glass.
That seems different than the record here, because what you're attributing to the tenants is, you're suggesting that they knew that there's booby traps, but they're nevertheless walking on the property, and that they're telling someone else. That seems a far cry from, I know this glass was made from, is not as sturdy as it should be. The fact that they didn't warn anyone, and the fact that they're walking around the property, doesn't that suggest that they don't necessarily appreciate that the property's booby trapped, and doesn't that suggest more that they're simply aware that explosives were made on the property?
Well, two parts. One, I think the court is focused on the existence of booby traps, but I think that's too narrow of a focus. It's whether they believe the property, I think, was dangerous, whether it contained explosives or not. And two, the fact that they walked the property, there's testimony that, yes, they walked the property, and appellant has argued that that means that they knew or should have known or didn't realize the property was dangerous. First of all, there's no testimony that they walked the property within a week before the incident. And that is the triggering point, because there's testimony in the record that says a week before the incident, we knew it was dangerous. And there's nothing in there that says we walked the property.
Well, we knew there were booby traps, or we realized there were some hazardous materials on the property.
The testimony is that we believed it was dangerous, I believe, Your Honor. It's not specific to we thought there was explosives or we thought there was booby traps. And I don't think it needs to be. I think if there's a concern about being on the property, which Ms. Garner testifies to, and they failed to warn, I think that triggers Restatement Section 358.
So if we back this up to the time of conveyance, Mr. Abney saying that your client, Galvin Peak, Mr. Johnson specifically, had an affirmative obligation once it was disclosed that munitions were manufactured and detonated on the property to investigate prior to the purchase.
Mhm.
How do you address that?
I think the court has already addressed it, and I'll rephrase it. The remediation efforts by the state and federal government, it almost acts, at least in my head, and maybe it's not the most articulate way of saying it, but as an intervening, superseding event in terms of the concern that a reasonable person would have as to whether the property is dangerous. The fact that the federal government, and I'm going to quote from the state's press release, it's
Well, the federal government's not
I'm
very
sorry.
much helped, because the state said they clearly had not finished. But if you could focus on what the state government says.
I misspoke, Your Honor.
Okay.
I apologize. The state government, Governor Hull, her press release at the beginning of the remediation efforts was directing the state government to take whatever action is necessary on the property or any other place to eliminate, monitor, abate, mitigate, remediate, or otherwise remove the hazardous condition thereon, including but not limited to any hazardous materials, explosives, or other materials.
But that flies in the face of the disclaimer the state included and provided to Charles Byers' brother. Was your client under any obligation to investigate what documentation following the remediation was provided to the landowner?
I mean, how can you investigate what's not necessarily public record? There's no evidence in the record that disclosure, that disclaimer was public record whatsoever. They've never made a showing of that, so I don't think the court can consider it for any reason because it wasn't available. What was available was this press release and the subsequent release from the governor saying the property is safe. And not only that, they are entitled to rely on Charles Byers' assertions during the sale. As the court has already quoted, that there is no explosives left over, unequivocally. In addition, there is a provision within the contract itself avowing that there's no hazardous materials on the property, and in fact, it triggered litigation after this event occurred.
But the contract also said, and never has been. And that was something that Johnson was clearly aware was false. Is that right?
A fair point, Your Honor, but again, it's what a reasonable person would believe. All these factors stacking on top of each other, I struggle to believe any reasonable person would think this property still remained dangerous when you have an unprecedented event of the state coming in and remediating the property and saying it's safe.
We're talking about a reasonable person. I think a reasonable person would want to know officially what the state said and not rely on a press release.
I don't see how a press release isn't the official position of the state of
Well-
Arizona, especially when it comes from a governor.
Well, except the official position of the state, as Judge Campbell pointed out, specifically said, explosive materials, hazardous materials, and other hazardous conditions may be present on the property.
And
It
that
can't
is-
get any clearer than that.
That is the warranty that the state issued, But the very same individual, I believe it was Dr. Shamoun, I may be mispronouncing, he issued his own public releases alongside that clearly say that we remediated the property completely.
Let's say the disclaimer was specifically given to Mr. Johnson, that he was aware of it. Would your analysis be different, that was part of the sales package, the information that was provided at the time of the sale, that he got that disclaimer? Did he have an obligation to go beyond? Would he have had an obligation under those circumstances?
I don't think he has an obligation to go beyond to do any investigation once he's had all the assurances he can have in the world.
But so even if he has this disclaimer where the state says, but we can't guarantee that there are no longer explosives on the property, that wouldn't trigger a duty to do a little bit more inspection before renting it out to other people?
Your Honor, I would concede that would change the analysis, but that's not the case here. It was not given to him. There's no testimony in the record that he has knowledge of it. Robert Byers is the only one who has it. He testified that he never told anybody about it. He testified that he barely even read it himself. So there's no evidence in the record that they were aware of this. And again, you have to analyze it from a reasonable personal
Well,
standpoint.
I agree that there's no evidence that they were aware of it, but I guess it goes to their best argument seems to be that a reasonable person wouldn't just rely on press releases, and you should be looking for documentation when you buy property. You would want to see the documentation that the state provided, as opposed to just listening to a soundbite on the radio.
Or Twitter.
And to go back to Mr. Abdi's point, from a convicted felon, the information came from a convicted felon. So they have all of this that says, maybe we better look a little deeper into this.
The information came from a convicted felon, but again, the information also came from the governor of Arizona. And I would argue that a reasonable person would look at what a governor says, and frankly, I think it's a little bit of a lawyer argument to say you should have done more of an investigation and not trusted the word of a state official in a public press release to do further investigation. With regard to the trespasser issue, to me, it's unequivocal. There was no authority for Garner and Perrin to authorize plaintiff to remove anything from the property. The testimony is that Ms. Garner told Alan Johnson she was removing certain things from the property, and he said, okay. But clearly, once he says, pay rent, sign a lease, or get off the property, and they refuse to do those things, and he says, get off the property or I'm calling the sheriff to remove you, any implied authority that they possibly could have had was clearly revoked. They could not have further conducted any authorization to allow anyone to take anything off the property.
But he didn't say get off the property now. He says get off the property by the date this incident occurred. Is that correct?
Not quite. It was an issue at the trial court level. I decided strategically not to raise that, but the testimony in the record is please get off the property on November 3rd by 3 o'clock p.m. They did not do that, and there's further text messages between the two of Alan Johnson and Chelsea Garner saying, I can't get off today, I can get off tomorrow, and the response was, just please keep someone else off the property. He really didn't acknowledge it one way or another, but the directive from Alan Johnson was to get off on November 3rd, to the extent it matters for the court's question.
So if we back it up and this occurs on November 3rd, does that change your analysis of invitee, trespasser, lessee,
I don't think
licensee?
it does. I'm sorry to interrupt. I don't think it does because at the end of the day, they still had no authorization to allow anyone else to remove property, even assuming it's true that Alan Johnson authorized them.
But if you're allowing someone, you tell the lessees, okay, I want you off by, let's say the 4th or the 3rd, and you know that they're going to be moving off the property at that point, you're saying the landlord would object or not expect that anyone will help them move off the property? Why wouldn't they just be included with, it's okay for you to stay until the 4th, and I want you gone by the 4th. If they have friends who come to help them move, wouldn't they also at least be licensees on the property at that point?
Whether somebody is foreseeable that someone else could come onto the property, one, the Kuraz case very clearly just recently said from the Supreme Court, foreseeability is not a consideration for duty. But putting that aside, that's a different question from whether or not Garner and Perrin had authorization to allow plaintiff to remove scrap metal off the property. Whether that he could be there is another question from whether he could take things.
Let's say the facts were just your lease is up on the 4th, and on the 3rd, they're cleaning up and taking scrap metal, which seems to have been, the landlord seems to have acquiesced in them doing that previously. Would that have been improper for them to do that on the 3rd? Let's say they were paying their rent, everything was paid, but the lease ended on the 4th, and on the 3rd, they're still cleaning up the property and they take some scrap metal. Would there be any problem with them doing that?
Again, those aren't the facts of this case, Your Honor. I think it would change the analysis, but they were a day late, and there was no authorization from Gallaudet and Peak for them to take things. But to the junk issue, the characterization that specifically the fridge was junk. It's interesting. In essence, plaintiff is asking this court that a squatter on a property can declare an item that they don't own, junk, and then authorize a third party to come and take it. If that's the case, I'd like to declare Mr. Abney's car junk, and I'd like to drive away with it after this oral argument, because who am I to say what is or is not junk of Gallaudet and Peak's property?
But didn't the owner acquiesce when the squatters previously told them they were taking property, and he's saying thanks for cleaning up the property?
Yes, but Ms. Garner's express, the one restriction she gave was don't take appliances. And who is she to characterize whether an appliance is junk or not when it's not for property? At the end of the day...
Did that mean working appliances? That meant old appliances laying out on the property?
I think it's a broad stroke. I mean, an appliance is an appliance. She didn't say non-working appliance. She didn't characterize it in any way. And her testimony is clear, which I've quoted to the court. I won't reread it here. But she clearly says appliances are off limits. And I very clearly made him aware of that.
So does this entire case, what Lane was on the property at that time, hinge on whether he was removing junk or a refrigerator? And is a refrigerator junk?
I don't think the entire case hinges on that. I think there's many backstops that I've placed in the record that show that summary judgment can be affirmed in Gallaudet and Peak's favor. The restatement issue, this trespasser issue, I don't think hinges entirely on whether you characterize the refrigerator as junk or not, because I don't think he had authorization to take anything in the first place. And a lot of the testimony that plaintiff appellant has provided in the record about what this refrigerator was, specifically as it relates to, for example, the officer report. First of all, it's hearsay. The court can't consider it. But second of all, the officer's report says the things inside of the SUV were junk, not the refrigerator strapped on the back of the car. And that, I think, is an important characterization to the extent the court should even consider that testimony.
Does your case hinge on how we characterize Mr. Lane on the property? Does it matter if he's an invitee, a guest, or a trespasser?
No, it does not, because under the restatement provision, because it applies, the duty to warn or invite, whether it's a trespasser, invitee, licensee, is severed. It doesn't matter what his status is. It matters more to the extent when you start to consider whether he is a trespasser, his status, but under the restatement provision, it does not matter. The one thing I will say is, very quickly, there is a specific statute that I cited in the briefing, Section 12712C. It was not addressed in the response briefing, and that also reminds me that there are significant waiver issues in this record, specifically relating to the restatement arguments. It was not responded to in the MSJ briefing. There was a supplemental legal authorities filed later on, but it was not really authorized by the trial court, and we moved to strike. And then there's some language in the motion for new trial by the trial court judge recognizing the waiver issues. So with that, I would just like to reserve the remainder of my time.
Thank you. Mr. Abdi.
Okay, I have an extra hour, would be helpful.
Could you address very briefly whether the lessees were on notice and why that doesn't implicate the restatement analysis if they were aware of the danger?
They weren't aware. parent was not an explosives expert. He had some experience in the military, and he never said that there were explosives or booby traps on the property. Now, Garner's testimony about what she was thinking a week before they left is interesting, and it's very ambiguous. I don't think it's what my colleague across the aisle described at all. She said something to the effect that things started to come together, and it was just weird. But she didn't say anything about suspecting there were explosives. Their conduct disproves any hint that they thought there were explosives on the property. They were there, their children were there. They found a container, like a film canister-sized container, that had a powder in it. They didn't know what it was. It turned out to be lead stiffenate, which is highly volatile. If I dropped it from this distance to the floor, we'd blow everybody up on the stage. And they put it in their kitchen, where they and their children would eat and prepare meals and spend time together. They had no clue that there was any danger on that property other than there was scrap metal around. And of course, they weren't leaving because they're in fear that they had to get out of there because there were explosives around. They left because it was time for them to leave. Let's see. The state did lie. They were briefly party in this lawsuit as a defendant, and one of the first things they did was they named the FBI and the Bureau of Alcohol, Tobacco, and Firearms as non-parties at fault for failing to remediate the property. Now, it's an admission that the feds didn't do their job. And of course, if you had just looked at the paperwork and the transfer of the property, you would have found out that the state admits that it really didn't, it could not certify that it did its job as well.
Let's talk about that. The state disclosed in a disclosure statement provided to the brother, that's not part of the public record. It isn't part of the chain of title of this property. Where is it?
Oh, well, I say many things about the state. The state never loses anything. It's there somewhere. And if you did a public documents request, which is what I would do, a public records request, I say, I want every piece of paper relating to the sale and transfer of this property, that would have come up because they had it. And you would have found it. And that would have been enough to say, hold on now, we're buying property where even the state says there may still be stuff there. Let's investigate further. Let's find out what's there. Get somebody on to do a survey of it.
So you're suggesting a buyer has an obligation to do a public records request before going through with the purchase of property?
I think reasonable jurors could say under these circumstances, when a convicted felon is telling you the sun's rising and you get information that the sun is setting, you've got to really be cynical about this and do some due diligence. So yeah, and in these circumstances, yeah, there's an obligation to look further, and they didn't.
And that's time, Mr. Abbey.
There's a duty to do that. Because isn't that what we would have to say, that there's a duty to do that?
If you want to do it in the simplest terms, and I understand that you are a man of simple, not simple thoughts, direct words.
Thanks for calling me a simpleton.
You could call it obligation, liability, responsibility, or simply duty. It all comes down to the same thing. And thank you very much for the time. I appreciate it.
Thank you, Mr. Abbey. Mr. Ackerman.
I would point the court to the record transcript of the oral argument proceeding on November 30th, 2016 at page 6421, lines 21 through 25, where plaintiff conceded during the administrative oral argument that Gardner was aware that explosives were on the property. It's one area where it cannot be disputed. I would also point the court to index of record 137 and 195, both talking about paragraph 31. It's the statement of facts and their response.
There's something that suggests booby traps as opposed to just there were some explosives that were found in specific areas on the property.
It's where that they had conceded that the Arizona government had cleaned up all of the explosives and the hazards on the property. All is the operative word, Your Honor. I would also mention, to the extent that concerns are relevant, walking the property, Alan Johnson and Charles Byers walked the property quite a bit during the sale. If there was any concern about walking the property and it being dangerous, it must cut both ways, because they clearly didn't think it was dangerous by walking the property when Charles Byers was showing him the property several times. Alan Johnson had his family out on the property several times.
But that would be a concession that the tenants didn't have sufficient knowledge but to suggest that they should have warned someone else.
The key distinction, though, Your Honor, it's a valid point, but the key distinction is that Garner testified a week before the accident that she was concerned about being on the property, and there's no narrowing of her testimony that she walked the property after that determination, and I think that's the distinction between what my client
There's
did
no
and what she
dispute that she did, in fact, they were still on the property walking around.
moving out of the property because they were ordered to do so. Your Honor, thank you, Your Honors.
Thank you. Council, we thank you for your arguments. All of you, thank you for your kind attention. We will take this matter under advisement.